The order passed by this court in this matter on 6/2/2023, not challenged till now, is required to be quoted. That order is quoted. I placed that order with the.
No, Mr. Dotto, where they called for the aptitude test.
Yes. We have all records annexed. I'll not go elsewhere.
So
This paper book itself.
The evidence which was extracted as you were submitting, that is relating to the issue whether aptitude test was held or not.
The issue which the Honorable Judge considers at the time of final adjudication is only confined to whether or not aptitude test was taken.
Yes.
Although, no pleading was there. That's why, I have taken your lordship through the writ petition. Then, if your lordships may kindly skip over the table at page 617, after the table, no question was asked by the appealing parties to the above interviews. The evidence kept on record. It is to be remembered. This is the quotation of that order. I skip over those. Now, please take paragraph 10. Then page 618, para 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. Paragraph 10.
Yes.
But so long, the finding was that no aptitude test was taken. The interviewers have made contradictory statements in course of their deposition. Now, kindly see paragraph 10. Therefore, the marks given to the candidates against aptitude test is wholly illegal.
Maybe the judge thought that the aptitude test which had been held is not in terms and in consonance with the rules.
Well, let us simulate whether that has been held or not.
This issue as whether aptitude held or not, this I think will go because subject to what you say. Because maybe Lordship was proceeding on the basis that test which was held was a sham test.
Right.
That is, I think, the ultimate.
There cannot be two
versions.
Two versions. Either the aptitude test was taken. If taken, it is faulty or correct. That can be one situation. The other situation was no aptitude test taken.
Okay.
So long, we had an understanding from the judgment that
there was no
aptitude test. Therefore, the marks given to the candidates against the aptitude test is wholly illegal and false exercise to hoodwink all concerned, including the court. The board has not given any reply in respect of awarding 9.5 out of 10 marks to a large number of candidates, which is absurd and an impossibility, especially to those whose academic score and TET score were very low. The table given below substantiate the allegation apart from 121 pages booklet, spiral binding, which is on record. The spiral binding cannot be a pleading or an evidence.
So who made the spiral binding?
The petitioners. Read petition.
Record with us.
Yes, that we have put in the paper book. It's in the paper book.
Yes.
In support of their allegations as to corruption in awarding marks in the interview, the petitioners have filed a booklet of 121 pages on the basis of which it has been alleged that the candidate whose marks were very poor in secondary, in higher secondary and in TET has been given 9.5 out and 10 marks, that is full marks out of full marks 10, that is the perfect 10 in the interview and aptitude test. No aptitude test was taken at all, and the allegation that there was no aptitude test which has been proved before me. Who has proved this? The proof has to be preceded by an allegation, an assertion, a pleading.
Yes.
But how it has been proved, I'll come to that later on. But before coming to the conclusion that it has been proved,
yes,
one must come up with an allegation. Proved before me from evidences of the candidates and from the interviewers which are kept on record. Here, to elicit the truth, I had to exercise my power under section 165. For example, some particulars have been given in the said 121 pages booklet, which has been prepared from the particulars published in the web portal of the board. By the board, some candidates' marks were reproduced herein below, which shows that the marks awarded to such candidates whose results are very poor in secondary and in higher secondary examination and also in TET are wholly absurd. Assessment in interview, and unless some extraneous factors, which includes corruption, as has been alleged by the petitioners and now has come to light from the investigation by CBI and ED, such absurd marking could not have been made by the interview boards in different districts. While looking into the following particulars, it has been noted by me that in the academic assessment and TET, 1. The maximum marks that could be given against secondary examination score of a candidate was 5. The maximum marks that could be given to a candidate against high secondary examination score of a candidate was 10. The maximum marks that could be given to a candidate against TET was 5. Therefore, the maximum marks that a candidate can get against the above three heads is 5 plus 10 plus 5 is equal to 20. Now I give example of a candidate before giving a table prepared from the document or record, that is the 121 page booklet. This candidate has got 2.866 in TET out of 5, 1.462 in secondary out of 5, and 3.050 in higher secondary out of 10, totaling to 7.378. But was awarded 9.5 marks in interview and aptitude test. Aptitude test was not taken out of 10, whose total score came to 16 point so and so, and thus he became eligible for appointment as a primary school teacher. Huge number of such absurd awarding of marks has come to light through the said booklet prepared from the particulars published by the board. Miller examples given. For example, Putul Bormon Singho, total marks in the academic qualification is 7 point something, and the interview marks is 5.0. Similarly, Monimala, etc., etc. This is the Honorable Judge records. Then kindly, after the table, para 15. The board has not given any reply in respect of the allegations of the petitioners in the pleadings as to non-empanelment of the reserved category in the panel for general category candidates of those reserved categories who got better marks than the general category candidates in the open competition. Thus, the board has violated the law declared by the Supreme Court and has committed extreme illegality. Though the relevant Rule 7 of the recruitment rules of 2016 mandates constitution of the selection committee, no selection committee was constituted for the purpose of selection of eligible candidates and preparation of panel of such candidates for appointment of teachers. It was done by one outside agency, a third party, which was not at all a part of the board, and this third party was named as confidential section of the board. This is clear violation of the recruitment rules. The board has maintained complete silence. From the gross illegality in the selection procedure in recruitment exercise of 2016 conducted by the board, it is clear that the board and its officials, including the former president who is now in custody so and so, conducted the whole affair like affair of a local club, and now it is gradually coming to light by investigation of Enforcement Directorate that jobs of primary school teachers were actually sold to some candidates who made money to who had the money to purchase the employment. A corruption of this magnitude was never known in the state of West Bengal. A former education minister, the former president of the board, and a number of middlemen through whom the jobs were sold like a commodity are now behind the bars, and the CBI ED investigation is being continued now in full swing. Well, with respect, paragraph 17 has got nothing to do with the merits of the matter.
It's a scam, Mr. Dotto.
That scam, what they say, scam, please see whether at all there was anything in the petition.
No, right. You have told us
yes.
that there was
nothing was there.
Simply,
using this catch expression, scam, corruption, doesn't mean that a case is proved. A case has to be proved even if it is scam.
So there will be no perception of the judge.
Milord, in that case, Milord, the judge should first release the matter.
First,
Release the matter with
the
respect.
perception in the sense from the records.
Milord,
not
no,
his
these
own
are not on record. Milord, these are the personal views of the judge. But how could the honorable court get the name of that third agency?
If it is ultimately shown by them that their system,
Whether it is shown by them, right?
these are all factors inextricably bound. You cannot segregate without.
No, these were not placed before the court. I'll come to all the pleadings one by one. It has to be there in the pleadings.
The pleadings you have shown.
Nothing is in the pleading. I'll come to the other pleadings. I've just taken your lordship through the writ petition. Other things where and the sequence of pleading is also very important. When did the court invite which pleading? That is also very important. Where I have a short list of dates for that also.
So that we will hear. We are
Yes.
just interacting with you.
Right.
We are asking you.
Yes,
that
yes.
when there is such a heart-throbbing issue of scam, which you say that it has to be different definitions can be given. But it is a fact that there had been a scam in respect of several education.
But that will not, Milord, vitiate the other selection process. Milord, one selection process said to be bad doesn't mean, Milord, the
can be argued against you that in order to divert from that issue, you are taking up the very basics as to whether there were any pleadings. Maybe this may be an argument on their side.
Yes, yes,
also.
definitely. But I will deal with those also.
Yes, yes, yes.
But
Yes.
otherwise, Milord, the whole Milord, the writ jurisprudence, Milord, has to be rewritten.
Yes.
Where your lordships have in a number of judgments held that whatever is there in the pleading as well as in the evidence, the court will only look into that.
Even except in extraordinary cases.
Yes. That extraordinary case has to be made out by the parties, not by the court. Court is not going to make out a case for one of the parties.
Yes. Yes, page.
Yes, ma'am. But I was placing paragraph 17.
Yes, 17. You have finished 17.
Yes. Now kindly take paragraph 18.
Yes.
Now kindly see about how we are being dealt.
16 17 শুরু করো
Acha, 17 when I have not started. From the gross illegality in the selection procedure in the recruitment exercise of 2016 conducted by the board, it is clear that the board and its official so and so night পড়া হয়ে গেছে. Now please take paragraph 18. This is very important for me. Kindly see about how my arguments are being dealt with. It is a matter to be noted that the board in its affidavit in opposition while dealing with the pleadings of the petitioners, instead of addressing the allegation of corruption and illegalities in the recruitment process, raised some niceties of law and some principles of law, but however nice or however laudable, those principles may be, this court as a court of justice will fail to deliver justice, knowing fully well that sense of justice is much above the sense of law. If the writ application is thrown out on such niceties of law, as this will mean that in the name of preserving the law, the corruption would be protected, with which a constitutional court can never do, keeping in mind the soul of our constitution and the constitutional conscience. I say that in this recruitment scam, stinking rats are being smelled. So whatever rubbish I have said, that has to be dealt with by the court. Kindly see the next sentence. Even more alarming, the board placed some judgment before me in support of the niceties of the legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. These judgments are not required to be mentioned at all. But this is how, Milord, the advocate is being dealt. Say that these judgments are not applicable because of so and so reason.
At all in the facts of this.
No, he has not. I have referred to at least 20 judgments, not even recorded. That is why, Milord, with respect, Milord, the Honorable Court, Milord, bypasses the application of the principles by saying that these are niceties of law. As if, Milord, in writ court, niceties of law is not to be argued. It is a Bhakcha's court. Kindly see. Now, kindly see the expressions thereafter. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much, much above the ground realities, in which the unemployed youths live with tears in their eyes, because this recruitment scam is a crime against the society and also a fraud, where the board and its former chairman was well aware of the rules of the recruitment but cared a fig and started a play to hoodwink all concerned. I will only say that fraud unravels everything. Who has unraveled the fraud? Kindly, Millard, recollect.
ওই যে অ্যাপ্লিকেশনের লিস্টটা পাঠিয়েছিল। Yes. Yes, Vishnu. So there are total 44 appeals in this. We were told. Now those are arising out of the same judgment. Now how many petitioners were there in all these matters? Total number of petitioners, how many?
Millard, may I say this, Millard?
How many challenged the selection process?
140.
Only 140.
Only 140.
More than 140.
No.
Yes.
140 read petitions. Now any other person came into the zone?
No, not in the appeal, before the writ court.
No. Before the read court we are asking. 140. All the 44 appeals, let us clear out the facts. All the 44 appeals are arising out of the same judgment. And all the appeals are dealing with the case of 140 writ petitioners. There were no other persons. Whatever application for addition has been filed is by the teachers who are already in service. Right?
Not only that, my lord, who are in the same footing of the petitioner, that application is also filed because their petition is also pending, and the board submission is that, my lord, due to this pendency of this matter, they are unable to address the court. So that's why the additional party and one of the additional party.
No, additional party এখানে apply হয়নি।
One.
My lord, can two already on
Yes.
in the first order it is mentioned, my lord, can two is already allowed.
Who are the unsuccessful persons? So do you have that chart? How many persons in total are there? Anyway, please ascertain that. Yes. Yes, Mr. Dotto. No breather. Continue.
And there are several petition pending.
Yes. We are on paragraph 20.
Yes. But I'll just finish this judgment, Millard.
Yes.
Para 20.
Yes.
Then where paragraph 20, the affidavit in opposition of the board was filed when all pleadings of the petitioners, including the particulars placed in the court, were served and kept on record, and the board did not deal with those allegations and those material facts and necessary particulars. In such circumstances, I allow the writ petition. The appointment of all 36,000 who were untrained at the time of recruitment in 2016 recruitment process conducted by the board in the post of recruitment primary teachers were cancelled for various reasons as elaborated above. The board shall immediately arrange for a recruitment exercise. Rest is Miller how to implement the order.
So this fresh recruitment exercise which the single judge directed would be restricted to the self-same persons.
Yes.
Yes.
So my first is, Millard,
Then
But the other is made how Millard the judgment is to be
they
worked out.
will-
Yes.
such they will be acting as para
Yes,
teachers.
that may not be Millard
Yes.
essential for the present. Therefore, Millard, this is how Millard the litigation proceeded. Millard, one facet I have demonstrated before the court. The other is Millard as to when Millard the pleadings were called and what had happened in between. I'll place those also. Then Millard. Oh, but maybe come back after the vacation. Maybe.
Why vacation, sir? You can finish your argument at least, because your argument, your judgments we will take into account.
Wait.
Tell me. I will want- How long will you take, Mr. Dotto?
Millard, at least one half. Another one half.
1 hour.
One half. My half hour day. Millard, I have to show a lot of judgment. First is Millard, my judgments which I placed. Whatever judgments I have placed, Millard, has not been notable.
No. On factual aspect, do you want to take us to any other document?
Yes, there are some other documents which I need to take your lordship. But these findings, Millard, are not based on anything.
Follow Kartik.
আজকে কত আজকে কত রে আজকে হচ্ছে 7 I minded to hear it this side of the vacation, Millard, in that case. কে ভাই কে জজ সাহেবের সাথে কথা বলছি, তোরা তো কথা বলে কি আছে? আমি যদি বলি ছুটি করে করবো, জজ সাহেব না বলি?
Yes.
Millard, in that case, Millard, kindly keep it, Millard, in
It
the
is not we are minded, it is our work. We have to finish it.
yes.
It is our work. We would only request the councils to
Millard,
at
kindly
least you
keep
can
it, Millard.
shorten the time, because it is awaiting decision for a substantial
Right.
period. That is a request to the councils. Now it is up to you people to come and tell us.
Millard, kindly keep it, Millard, in the week of 19th, starting from 19th.
Then
When-
on that day you are finishing your arguments, and it would
But
have
I
been
hope
very,
so, Millard. But I
very
hope.
helpful to us had we got the list of judgments which you are placing.
But that period I can supply to the court. Not today, but in between I can supply. That I can give. Ah, 19th.
Yes, things are good. And if on 20th 2 p.m. you cannot finish, if possible, we will keep it as a continuing matter so that you can finish your argument. Prior to the vacation, at least you can finish your argument. So that now it is their turn.
We have made submissions, madam.
Yeah,
We have to make submissions. We are the successful candidates. We are not the first round application.
You are added applicant, sir. Which appeal here? Achha, please let us know.
May I explain, Millard? May I explain, Millard? দাঁড়াও এই পার্থ এক সেকেন্ড
So
there are 44 appeals.
Hmm.
One appeal is by the board.
Hmm.
The other 43 appeals are by the successful candidates who have lost their job,
Right.
or in other words, the 36,000 who have lost the job, many of them have preferred the rest 43 appeals. There are, my lord, certain.
It was granted to them.
Yes. And the applications which your lordships are facing, the addition.
But the successful candidates.
No, they are the unsuccessful candidates.
Oh,
Standing on the same footing with the writ petitioners.
Or the rate petition.
Fence sitters will deal
I am
with
the candidate.
There are also successful candidates who have not been implemented. They have also, my lord, filed an application for leave to appeal.
That the other applicants to decide among themselves who to the lead counsel among.
That way, I think, my lord, this matter cannot be decided.
at least
Everyone
there
has
should
sight
be
of,
there should be a subject to what you say. The arguments can be urged before us by any particular advocate. If any further addition required, let that advocate continue. So I don't know.
Opportunity to
The last
Pardon?
We will not repeat, but we may be given an opportunity to address you.
So you are the appellants, we will hear it. There is no problem with that.
The last question, my lord, also the same. Don't repeat. If you want to say something new, you're always welcome.
No, not new. You will certainly place your